and thank you for joining us for Bankruptcy Claims Trading, Episode 2, in the three-part series entitled Bankruptcy Transactions 301, Advice for the Advanced Practitioner. We have a very experienced and informative group today, and I am very pleased to be able to be your moderator. I'm a member of Getz Platzer in New York, and I lead the corporate restructuring practice there. I am joined by David Karp, a partner at Schulte, Roth, and Zabel in New York. David, say hi.
Thanks. Great to see you.
Stephen Rutenberg of Polsinelli LLP, a partner in the Miami, Florida office.
Hi.
There you go. And Matt Christensen, a member of the firm of Johnson May, based in Boise, Idaho.
Good morning.
Good afternoon. Good afternoon. Just a couple notes regarding the PowerPoint accompanying this webinar, which we are now switching to. It's available. We will not be working our way through it page by page. The PowerPoint is a reference for you to take away. This webinar, like all Financial Poise webinars, is a conversation, and we like to look and keep it that way. This webinar is a production of Financial Poise. For more information about Financial Poise, please go to www.financialpoise.com. A final note, if you're attending this live premiere of the webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send us an email at info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to answer. So with that said, let's really just jump right into it and talk about some basics of the claims trading process. Stephen, what's a bankruptcy claim?
Bankruptcy claim in its simplest form is a right to payment in a bankruptcy case. I'm sure everyone's familiar here with a bankruptcy case in which it's in its simplest form is an order for protection for a company to restructure. There are also bankruptcies where a company is not going to restructure, but the basic idea is you slow the process down, you put everything together, you see what are all the claims? What are all the claims against this company? Can the company restructure? Do you either set a payment plan for all these claims to get paid out, which could be anything from a union member which gets his contract renegotiated. It could be the dry cleaner in a smaller company. It could be a complex derivative payment. It could be an intercompany payment. It's any obligation of the company. They all get put into a pool. Sometimes it's a stratified pool, and it gets worked out.
Do they cite categories? Are there categories of claims that have different rights and remedies in a proceeding?
There could be. Some cases, all claims will be treated the same. Generally, the claim of an insider is treated somewhat worse, but that's really claim specific. A secured claim, meaning a claim that has entitled to security behind it, is generally treated differently. Sometimes it's not actually considered one of the claims because it has a right to its collateral. So, but sometimes you'll have bankruptcies with multi-classes of claimants, whether or not those get treated in the case. So actually, there's two answers to your question. There are multiple groups of constituencies in a bankruptcy which could have claims. One could be the equity holders, though their equity generally comes below debt. They're secured, there are unsecured. Sometimes there are workers, there are foreigners, there are Americans. Sometimes all those could consider themselves to be treated and want the court to be treated separately. And then there's a plan of reorganization put together by the court, and that plan could decide to treat everyone the same to the extent allowed by the law, or could separate that out.
Okay.
So it's
Question for the group in general, if you guys have a view on it, do you see any particular classification of claims being more readily transacted than others? For instance, do you see the transactions in secured claims more often than you'll see transactions in equity type claims?
It's a good question. And for our purpose, remember, when you're thinking of secured claims, you might be thinking of secured bank debt or bonds that are going to be trading among broker dealers in a big boy network. The purpose here, what we're really talking about, usually fall in the category, usually, of general unsecured claims, vendor claims, customer claims, claims that start with a unique individual contract against the debtor as opposed to an indenture or a credit agreement. And so while those specific claims, they might have, as Steve said, they might have their own particular security interest. Oftentimes, the types of transactions that we trade on and call are the general nomenclature for claims trading are in the general unsecured claims pool and those that are hanging around that hoop.
Okay. So
I
Matt,
very much agree with David
sorry.
on that. I'll just add that one of the complexities that we have, which we didn't discuss in terms of types of claims, is that a claim that a company or an obligation that a company makes after its bankruptcy filing, and sometimes under certain rules with close to its bankruptcy filing, has priority status, in which case it gets paid back after, I think, everything after the IRS and the lawyers. So it generally has a priority status. We've definitely all traded some of those, but as David said, the vast majority are the general unsecured claim, because as we're going to discuss later, what you're really taking by buying a claim is the case risk.
Interesting. All right. Well, Matt, tell us who buys these claims and why?
Um, the buyers of the claims tend to be traders, like at an investment bank, traders at a hedge fund, parties that are looking at that claim as an investment, right? So they're individuals, they may be corporate investors, that sort of thing. As far as why, really there's two reasons. One is sort of the financial benefits of that claim, right? I'm looking at the bankruptcy case, I'm looking at what the projected return on claims is. I'm calculating what my risk is, and I'm looking at what the return on that investment might be. That's going to dictate how much I'm willing to pay for that claim. From a seller's perspective, I'm selling that claim because I don't want to deal with the risk. I'd rather get immediate cash now, and I'm willing to take a discount on it. I also may be buying that claim for strategic reasons. Maybe it gives me leverage in the bankruptcy case. It's a large enough claim that it controls the unsecured creditor class. And so me voting for or against the plan will make a difference. But it may be that I'm buying it for informational purposes, right? Maybe I'm a competitor of the debtor, and if I can buy that claim, I get a lot of sort of insider information about that business operation, and or maybe the claim treatment is providing equity to some of those unsecured creditors as part of the plan, and so now I've got an even better look inside the competitor's shop. So different strategic reasons why I might be willing to purchase a claim and sell a claim too. And so we may get into some of those a little bit later as well.
Again, a general question to the group. Is there a specific group that you guys cross more than others? Like, for instance, do you see more strategic people? Do you see more investor people? Or is it really run across the board? If there is anyone out there that ultimately has, sees groups of people, do you
It really continues to evolve, right? And you have distressed debt, hedge funds, and private investment funds. You have high net worth individuals and family offices that have gotten more active. With the investment funds, when you're running a $4 billion investment fund, it takes a large case and a large claim for you to get involved and for it to be worth your time to underwrite and transact in that claim. As Steve probably saw, we just came off of, FTX is one of the largest claims registers ever traded. You had a lot of small claims and large claims. So you had investment funds at kind of one end of the claims buying population, and then you had a lot of newcomers and high net worth individuals, and even crypto traders that were buying off of exchanges. So the market continues to evolve, continues to become more efficient. There's a tremendous amount of interest from different types of parties in cases that have an opportunity for an arbitrage trade in different classes. But it's really something that has grown out of, as the growth of the industry and the growth of the buyer population is really something that came out of kind of the Lehman, Madoff, MF Global vintage more than a decade ago. And that population really enjoyed those trades, did extremely well, and are always on the lookout for those types of cases, which don't come around that often.
Absolutely.
Yeah, and I would just add to that. I think that's, I mean, at least from where I'm sitting, I think you might be able to make somewhat of a differentiation, but in the larger cases, most of the buyers that we're seeing are doing it mostly for investment purposes. They're particularly not trying to get involved in the case. They don't want any to own securities. They don't want to get involved, and they're doing it because they think it's selling at 90 and it's going to go with interest to 120 or something like that. What I'm seeing more is the stuff Matt was talking about in smaller cases, particularly some of the nursing home cases that we're involved in, where people are buying claims for information. They're buying claims to make sure they have standing. They're buying claims for a lot of other reasons in some of the smaller, even single asset cases and things like that.
Interesting.
Steve, you make a really good point that generally speaking, these claims are viewed as non-securities. So it's a big boy market, meaning that you're trading on an informational imbalance waiver, and you need to do your own homework and be comfortable with that. But Steve's exactly right. For the most part, what we see is it's investment opportunity. The different strategic reasons to get involved in the case that Matt raised are excellent, and he's correct. But those are done. We see those farther and fewer between, although they are done very well by great strategists in different cases.
So again, the question to the group, who do you think this information imbalance favors more?
I think that's a fascinating question. I actually think that's probably one of the key takeaways, which I have to say from here. I think there is an assumption, and there was even, if you look at the Madoff decision, early in Madoff, when the judge allowed claims trading, he's like, I'm not going to let you guys screw these people twice. And there's a general assumption that you have these claim traders which have the excess information, and they're taking advantage of the poor mom and pops with claims. My general experience is the opposite. I think more often than not, the claim sellers have much more information and don't well, they're often insiders. And again, these are securities. I mean, I think we're going to get into valuation later, but one of the important parts of valuating claim is how big the claim pool is. And there was one between Delta and Comair years ago, and it was clear that one of the parties knew that there was going to be a multi-billion-dollar claim, which was going to increase the size of the claim pool, making everyone get paid out less. So I've seen so many times where it's the seller with more information, even though they're the ones who claim to have lost. So it goes both ways, but I'm going to take kind of the counterverting view that it's often the seller with the excess information.
Steve, I think you're right. I think the interesting part, I know we're gonna get into this also, structurally, and the risk allocation between the buyer and seller, the buyers are often in the seat of strength. But I think you're right, as far as informationally on the value of the claims pool, and the access to information at the outset, oftentimes the sellers may have an advantage. They may not have the wherewithal to do the underwriting and processing of that data.
And even on practical basis, not to be the defender of Wall Street, but I've had far more claims in which it's a tree vendor in PG&E in the big California bankruptcy case, which was kind of retrading their claim, rather than the Wall Street buyer, which was basically accepting the trade confirm as is.
Interesting. So Dave, let's talk a little bit about crypto claims. It sounds sexy. What is it?
The answer is, well, I'll give you the great lawyer answer. It depends, right? It depends. It depends what the contract says. And I have a really interesting anecdote. We started looking at, there's 300 different crypto exchanges, and you're onboarded as a larger client through something that would look to most people like a prime brokerage agreement. And in, I guess, 2020, we started having to look at a number of these agreements at different exchanges. And it became apparent that the rights of the investors who are onboarding their crypto to the exchanges, those agreements were wildly different in their what they said and their quality. And what we remember what we were thinking was there's going to be a problem here. And there's going to be fraud here. There's going to be different kinds of counterparty credit risk problems and bankruptcy claims. We had no idea where it was going to come from, and never would have guessed in a million years that the FTX bankruptcy would have unfolded the way that it did. But ultimately, what is a crypto claim? It depends, right? Or what does your agreement say? Do you own the crypto? Do you have title to the crypto that is being held on the exchange? Do you have a derivative account like your checking account that merely references exposure to a certain asset that is owned by someone else? Is there permission for that exchange to rehypothecate it? Do they have to hold reserves? Are they going to be treated as, is your crypto going to be treated as customer assets? And so as we started, as the crypto exchanges like Celsius and FTX started unfolding, you started seeing that there were very different answers depending on the terms of the documents for each case, and for, in some instances, different account types within each debtor.
Interesting. So Stephen, let's touch a little bit about valuating claims and valuing claims. I know that's a very difficult topic that we could probably spend an entire webinar on, but can you give us, just some general concepts in terms of, how they're valued for the public?
Well, as I was kind of mentioning before, I mean, the simplest way of looking at it is you take the assets, you take the total claims of a company, and you take the total claims of a company, you take its assets, and then somehow that gets divvied up. That sounds much simpler than it is. Even the core rule that you have a bar date in a bankruptcy. So as of X date, everyone has to file their claim. And so in theory, you should know what the claims are. The problem with that is that new claims could be created in a bankruptcy. For example, you have a union, and this happened with all the airline contracts, in which the pilots were being paid $300,000 a year, and then they settled for $200,000 a year. That gave each pilot, for each year of their contract, a $100,000 claim, which often got bundled and settled. Which what that did is it added a lot more claims to trade, but it also added the total pool of liabilities of the company. So that pool could increase as the process goes on. So one of the parts, when often the seller knows more, is you have to know what is the claim pool and what is that going to be. Additionally, really, is the claim going to be converted into equity, or is it going to get paid back? Not that there aren't many other manifestations of what it could be. And finally, a point to think about with valuation, and this is generally what we saw in PG&E in California, where it was clear that the debtor was solvent and they were going to get paid back 100%. And the real question was what was the interest is going to be? Because before the equity, a general bankruptcy point that's important to make, before the equity could get anything, the debtors, all the creditors have to get paid back plus interest. And in that case, it was actually litigated about whether or not what rate of interest do you use? Do you use a federal rate of interest, or do you use a state rate of interest? So those are kind of a few points on valuation, and thinking about the other claims out there. I mean, there's always a chance that you'll have something that's not considered a claim. I mean, what David was alluding to in the crypto cases is that many people thought they don't have a claim. I actually have a deposit. I want to get it back. And whenever you're buying a claim, you want to think about what happens if this is not considered a claim. Generally, it's documented that you just would get your 100 cents on the dollar, but that's an issue to think about with it as well.
So interesting. So Matt, let me ask you, I mean, this is not a regulated industry. You know, how do you know if a claim has been sold? And how can you confirm that you're actually the right party is actually holding that claim?
So I'm answering this as if I'm representing the debtor in the case, which it really would apply to potentially other creditors as well. But assuming the bankruptcy case had been filed, there's a rule, Federal Bankruptcy Rule 3001 that governs transfers of claims and filing proofs of claim, filing notice, that sort of thing. Generally, if a claim has been transferred before a proof of claim has been filed in the case, then the buyer can file the proof of claim and assert that it holds that claim. If I'm the debtor and I see that proof of claim filed and there's a different name on it from what I have in my records, I'm probably going to follow up with that party and say, hey, who are you? What is this claim? And they may provide me a copy of the transfer agreement or whatever. But if it becomes a little more interesting when a proof of claim has already been filed, and then the transfer happens, generally then the buyer has to file a notice depending on the type of transfer. If it was just a straight transfer versus a security interest, the notice is a little different. But the notice gets provided to all parties in the case, but specifically to the seller who filed the original proof of claim. And the seller has a time period to object to that transfer notice. So if I'm the seller and some random transfer document gets filed that I have no idea what it is, I have a way to go into the court and say that I did not transfer this claim. I don't know who this party is or what they're doing. But it also provides other interested parties in the case time to do that same objection, whether it's a full transfer or just a security interest transfer. So as with most everything in a bankruptcy case, there's a procedure where notice has to be provided, and it's usually provided by the buyer.
So let me ask the group, is there some sort of a group dynamic that you think exists out there in the claims process where all of a sudden you're monitoring a claims docket and you see ABC company, which you know is a very active claims buyer, buying up all these claims. All of a sudden now the other company's like, what? I can't miss out on this opportunity. Let's jump in and see what's going on. Do you see that kind of a situation unfolding in terms of opportunities? And is that how a claims buying service may scan to ultimately find opportunities, thinking that, well, I don't see it, but maybe they do, and so I'm missing something. Let's relook at it. Anything?
Steve,
I'll
you
let
wanna go
David go
first?
first. I'll let David go first, and then I have thoughts on that as well.
Yeah, it's an interesting question, and sure, different types of buyers use different mechanisms to scan dockets and tracing 3001 E's, but really what the great claims traders do is they do their own homework and they get there early and they find on their own, they find information to access the creditors and start dialing and building rapport with the larger creditors whose claims they may want to purchase. Back in, and Steve, I'd be interested to see what your thoughts are on this. But when we went through Lehman, the bulge bracket banks, your Goldman, your Morgan Stanley, Deutsche was great. Lots of different brokerage firms would go out and source large claims, and then they'd sell them to their hedge fund, private equity fund buying clientele. After Lehman, when the market became much more saturated, sourcing, like the banks did, became much more of the important art. and finding the claims because the market became so much more competitive. So again, love to hear Steve's thoughts on this, but I think there's all different methods in sourcing and finding access to that claim. And certainly once you get attention on cases, and we saw this in FTX, where the trading population starts to grow, you do get further interest. But I will note that I ran an auction I represented one of the top 20 creditors in FTX right after they filed, and they just wanted to get their liquidity and get out and move on and start trading. And we had 45 investment funds show up to get into the data room and evaluate a bid on that claim. And so, we knew where to find them, and they knew where to find us, which goes back to why it's so important to have a sourcing mechanism as well.
Interesting.
Yeah, I kind of agree with everything David said there. I mean, one thing to keep in mind is, at least for the large claim buyers, in the institutional claim buyers, it's a very competitive market now, and there is electronic registry of claims. It used to be very much the Wild West, but I would say, to your point, is that when we first saw on FTX, some of the institutional players, because some people thought it was too scary, too dirty, and things like that. When you start seeing some of the known bankruptcy players, it was like, okay, this is going to have a significant recovery, and people knew what the claims were, but that definitely led to more notice. And I've definitely had situations, which I think we'll touch on with documentation, is you have the option to file the 3001E and notice the court, but I've had clients which didn't want to file it and kind of embargoed it for a while to not give a public notice. That does give them counterparty risk with the seller, because the seller could, in theory, back out. But often what you have is you're titrating the risk between telling the public that you're buying this claim, and then therefore possibly preventing you from buying more, opening it up to your strategy, compared to the counterparty risk of still remaining on the hook for the seller, not for the seller not backing out, selling it to someone else, or something like that.
It's funny, you described the claims trading market just as I felt about the bankruptcy law market when I was a young New York lawyer, where all of a sudden Texaco and Weil Gotshal got into it. But before that, it was very unsavory for New York lawyers to ultimately have a bankruptcy lawyer in their practice. It was not something that they liked to have. And so all of a sudden, when Weil Gotshal got involved and made, tons of money, it changed everyone's perspective, and all large firms started having, white shoe firms in particular, White and Case and everybody else. Well, let's have a bankruptcy department because, that's where the cool kids are. But
And I think David probably remembers, like, after Enron, when claims trading started to become like something kosher and not done out of like a small shop in a basement in New Jersey. Nothing against New Jersey, and then I think we had a mini version of that 2 years ago when the crypto claims started to become kosher, and there was a similar moment in Madoff. At first point, the banks weren't touching those claims, and then they saw other people get involved, and that got kind of securitized.
Yeah, I've made a pretty good living not being the cool kid.
Very good. So, Stephen, let's talk for a minute about case risk. Talk to me. Tell me what case risk means to you.
So whenever I'm looking at a claim, there's always two risks with basically any bankruptcy claim. There's the risk that this is not a good claim against the debtor. Let's say you have United Airlines that filed for bankruptcy, and I have a claim against them because I missed my flight or they broke my suitcase. And let's say I file a huge claim for that. There are two risks there. If I file a $50,000 claim for my broken suitcase, there is that United Airlines says, no, you don't have a $50,000 claim. You weren't on this flight. At most, you have a $100 claim because that's what your suitcase was worth. So that's claim risk. And that's that the United Airlines will say you don't have a claim. You weren't there, or you have a claim. It's a suitcase. Yes, you have a claim. You're right. You have a claim. It's $100 claim. You separate from that, there is case risk. Case risk is United Airlines going to pay 10 cents to its creditors? Is it going to pay 120 cents to its creditors? For the most part, when people are trading in claims, not exclusively, but almost entirely, what they're trading in is case risk. It's in some ways a comparable risk to people buying the bonds. It's a little different, it has a little more hair, it has a little more upside. But what people are trading in, and I would wonder if David would agree, but the key point of the document is dividing case risk and protecting you, making you buy that risk and not having the buyer take claim risk, which is the risk that this individual claim will be rejected, often because it's an insider, and the claims of insiders can get rejected, other bad actors, or just, I didn't do those trees, or I didn't have a suitcase on the plane, or this is an exorbitant amount. So therefore, once claims get settled and there's an allowed agreed amount, there's a much more robust market. I mean, just going back to Lehman, they were the creditors and Lehman, or the creditors committee, was knowledgeable of this, that they said, we know you have a good claim, but we also know you want to sell it. So take the claim, and this is the face value of the claim, not the payment value of the claim. If you claim you have $1 million claim against us, we'll give you an $800,000 claim against us because we know you can trade it for a premium now.
Yeah,
Interesting.
I think this is what Steve just highlighted is probably the most important part of the hour. And it's the natural tension between what a claims seller wants to sell and what a claims buyer wants to buy. If I'm the gentleman that was filing the claim, or lady who was filing the claim against the airline and then selling that $1,000, $50,000 claim, when the hedge fund lady comes to buy it and says, I'm going to bid you 25 cents on the dollar, I want to take that 25 cents on the dollar. I want to slide my claim and the document across the table, and I never want to hear from anybody again. And there are certain risks as to that $50,000 claim that can be known by the seller. And then there are certain ways for debtors to attack and knock that claim notional amount down. And so who takes that risk? And buyers don't want to take that risk. And sellers oftentimes don't understand that it's a risk that they're guaranteeing or providing credit support for when they're selling their claim. So it's a really critical, it's a critical issue to the trade. It's why it's critical for you to call somebody like Matt or Steve if you're a corporate seller before you sell your claim. And before you sell your claim means before you even agree via email to a price subject to docs. And it's really one of the most important, to me, it's always been one of the most important issues in the trade process.
So guys, just as a general question, do you see a disparity in the contract as to what might be contracted in or out on claims risk? Or is there just one standard contract that, most of the sophisticated claims traders use and they're not really negotiated from them?
I would say the vast majority, and this is, I don't know if David would take it as far as I'm saying, I would say 99% of claims, the seller is remaining with its individual case risk, even if they don't think they do, which is why I will advise sellers generally. There are exceptions, but it's really difficult to draft a document with any reps and warranties that don't keep the seller on for individual case risk. For individual claim risk, sorry. It's very difficult to do that. If it is, it's a specific risk that you'll ring fence in the document. Like, we know blah, blah might happen. We know there's a set objection. That risk is being transferred. But for the most part, people who generally come and say, I want to sell my claim without risk, it doesn't happen. I mean, the only way to really do that is to put the claim into an SPV. Whether or not there's recourse is a different story. I have lots of buyers which are buying claims and they know that there's no real recourse to the seller because the money's going out or it's a liquidating entity. But in terms of the documentation, it's really hard to draft it unless you know what the risk is without it being with that risk being transferred to the buyer, without the seller having any residual risk. Because even any of its knowledge reps, basically, once you put any rep in a document, it kind of puts the seller on the hook often for a problem with the claim, unless it's specifically carved out.
Interesting.
I don't know if that's your experience, Dave, or you won't take it as far as
So
me here.
I know, like, I understand, and Steve's he's very experienced, a very well-known practitioner, and has a great experience. I don't necessarily agree that 99% is that number. I think it's the document and the preferred document that a buyer serves up. I think that is why it becomes so critical for a seller selling a large claim, especially one that does have a balance sheet and wants to deploy that capital somewhere else, to have an experienced attorney representing them so that they can work with the buyer and the broker to come to a agreement that works for both parties. I think, as Steve alluded to, once the notional amount can be settled by the debtors and frozen. So when we go back to Steve's example of the lady who was a $50,000 claim against the airline, once the airline agrees that that number, that $50,000 is the correct number, and you're taking case risk, there are ways to sell it with less risk for the seller and to come back to the seller. But look, I think it is a heavily negotiated part of the contract on complex claims. And I also see that this is where, when there's disputes and litigation and breakdown in the process, a lot of the times this is where things can go wrong. So I think it's really important for the corporate selling population to think about this and get counsel on it before they do their transaction.
100%. And often sellers don't have, and I guess part of the strength of my point is I often see sellers which don't have counsel and they sell a claim and they don't realize that, because they don't realize that they're really retaining, either through reps or through something else, that they're retaining the risk of something happened to the claim.
Right, right. So I actually want to explore that a little bit more, but I want to turn to Matt for a minute. And am I selling the claim, or am I taking an assignment of the claim? And which works, which doesn't? What's the difference?
My experience is the difference is in the words that you use, but not necessarily in the effect on the claim risk. So you can call it an assignment, you can call it a sale. Generally, from a bankruptcy standpoint, the bankruptcy courts at this point tend to say it doesn't matter what you call it, the claim risk resides with the claim. However you obtained it is up to you. And so where it may come into play more is, as Steve mentioned, the reps and warranties in the agreement, the indemnification clause, if there's one in the agreement. So those may be more robust in a sale document than in an assignment document, potentially. But realistically, at this point, my experience is it doesn't matter what you call it. You're obtaining the claim, and the risk of that claim, to the extent there is any, goes with you. That's why, or excuse me, goes with the claim. But that's why the representations, the warranties, the indemnification provisions, those are the contractual ways that the buyer is trying to leave that risk with the seller. But from a court standpoint, if there's an objection to that claim, the buyer's the one who's facing that fight.
Okay, so let's turn for a minute, if you don't mind, and Stephen, I'm going to come back to you on a more basic level. I'm interested in getting into the concept of buying a claim, and I hire you. What are you going to tell me to do? Besides not.
As a no, I mean, if you're buying a claim, that's often, in some ways, that's the easier, that's the easier advice. I mean, assuming you've already found the claim and you found the case. The first question is this an allowed? I'll tell them to hire David. It's all but I'll or at least to the seller too, if not. But I'll look at the first question is this an agreed? Is this claim been stipulated and agreed to for the amount of the claim? And if the claim has been stipulated, and then the next thing we'll probably check is this a case that's still allowing transfers of claims? Particularly, and I'm sure this is something David's seeing a lot with some of his clients doing prepackaged bankruptcies and pre-organized bankruptcies, that often there's a very small window. And often they want to have the holders lined up almost at the filing. And so, because there's two risks here we're thinking about. There's if I'm the buyer, there's the risk of the case and there's the risk of my counterparty, which could be in two situations. One is the risk that my counterparty doesn't really hold the claim. And the other risk is that they get the payment and not me, and they run off with it, which gets to what you were discussing with Matt beforehand. If the claim isn't assigned, you remain with that counterparty risk. So thinking through, how do you protect with the document both of those risks from the seller, and that the risk that the claim isn't transferred and the seller keeps it, as well as the risk that there's something wrong with the claim and I can't find the seller. And I think many of those things get put into the document, as well as, and this is a side point with many of these claims, is it's often easier to have a small mistake than a big mistake in terms of losing money, meaning there was a payment made prior to bankruptcy. There is sometimes small issues with the amounts of the claim. Your client it may end up having a material difference to it. And maybe there was a PIK payment on something that wasn't included. And sometimes making sure that you have the numbers of exactly what you're trading. Another issue which I've dealt with on a claim is there were two similar claims trading. One had a parent guarantee and the other didn't, and there was a price difference, and our client bought the wrong one.
Wow. Okay. So that's interesting. I think from what I've heard from you so far, it's obviously get a lawyer who is experienced in this area, in this particular industry, because there's a fair amount of due diligence. There's a fair amount of what I'll call document standard provisions, which some counsel may know and some counsel may not know, depending on how extensively they practice in that particular area. Would you agree?
Definitely.
So Matt, so now my client, who is a baker, gets a call that Hostess filed, and they're a creditor of Hostess. And am I interested in selling the claim? What do I need to look at? What are those issues?
So is there competition among the buyers? That may be one question I'm telling my client to look at. How many offers have you gotten? Is it something you can kind of use those offers to play off one another and get a better price? I'm looking at evaluating the potential risk of a claim objection. And that may come in the sense of just an objection to the claim itself. It may come in a lot of those bigger cases. There's threats of preference payment avoidance claims that would offset whatever my personal claim is. And so is that going to be a risk? Because if the transaction essentially leaves all that risk with me, I got to prepare for whatever defense there may be. Or am I far enough in the process that claim is essentially an allowed claim at this point, and there's much less risk? So how much risk is there? And then of course, how much does the client want to spend on its own due diligence and advice to have an attorney review the contracts, have an attorney negotiate the stuff? What's the potential downside? So if I've got a claim, it's I've got a case right now where we're doing a administrative convenience class for the smaller unsecured creditors, because it's going to be a 7-year repayment term for unsecured creditors on a $20,000 claim in a case with over 300 million in claims, you know, I'm getting a very small check for 7 years. Versus, is it better for me to say, look, I'll take $5,000 now on this $20,000 claim and wipe my hands of it and move on? That's the evaluation that client's got to do too, is what can I do with the $5,000 now versus buying myself a cup of coffee once a month for the next 7 years. So all of those evaluations, but that, you know, that's the same type of evaluations they'd be doing for almost any sort of transaction that they're doing. What's the time value of it?
So,
And I think that's just to point out, and that's a very, from the seller perspective, that's a very important point. I mean, I think we discussed why buyers would buy a claim. I mean, there are times in which sellers want the money now because they just need the money to run their business. There are times sellers want to liquidate. And then there are times which sellers may not care for the money now, but they think this claim is, they're pretty sophisticated at it, and they think the claim is overvalued, or they think this is the best price they're going to get. I mean, the best case of that is when I was dealing with the pilots union in, I think it was Delta, and they didn't even care that we weren't going to pay them, us the buyer, until the case came out of bankruptcy, which is a counterparty risk. But they wanted the contracts agreed to now because they felt this was a better price than getting than whatever they'd be able to sell the equity that they were getting later on. And the simplicity of that. So it wasn't as much about money of now, it was just about being certain of the cash now being versus whatever, didn't want to take a bet on United Equity, and they're working there, or Delta, which it was in both.
so I'm going to open a question to the group, which, to be fair, is a little off script, but it's always a question that I wanted the answer to. And I know I have a really good panel here, so I'm going to throw it out and see if I have any opinions on this. I'm a member of the creditors committee. Can I sell my claim? And are there any concerns that any of you would have about doing that?
Very unfair, very unfair. So the answer is, it depends, right? It depends on a lot of things. And are you talking about an official committee of
Yeah.
unsecured creditors where
I am.
you have duties to the broader creditor body and creditor constituency, or it could be, right? We have ad hoc committees in all sorts of different cases where you expressly are a group, but it's every man for themselves, and you expressly agree not to sign up. Are the things that are the essence of your claim, are they securities? Are they non-securities? Have you received case information? Have you are you a part of material negotiations on the case and received information that's not available to the general public? I think, Steve, the way that I view it is as a general matter, and I can't recall the case right now, but as a general matter, when you're on an official committee of unsecured creditors, your expectation should be that you are going to be restricted. You know, there are exceptions to that, but I think that's the starting point. Love to hear the other panelists' views.
Certainly, and this is probably the most important thing to keep in mind. If the claim is for if it's a security, meaning it's a bond, or it's a claim that relates to a security as defined by the under the Howey test and being a security, syndicated loans and trade claims are generally not considered securities. So they're generally, you're under the securities law. It does not fall under the purview of securities. And I'd say a few years ago, we would have said this was almost certainly true. There's a recent case of Kirshner versus JP Morgan, which I think made it 99.999% the case true, and clearly means you're not going to go to jail for it. So if the claim is not a security, you're in, not all the points that Dave mentions is totally right in terms of your fiduciary duties, and some of those fiduciary duties could even have criminal implications to it, as in a well-known case of a few years ago. But for the most part, you're not dealing with a securities law violation. There was a trader at Barclays who was on a committee and he bought bonds. People often think it was trade claims, but it wasn't. It was bonds, and he went to jail. So when you're dealing with securities, it's a much higher bar. And the fact that these are not securities somewhat makes it a little bit of a safer area to deal with, in which you're dealing with fiduciary duties. You could sometimes have something that looks like a trade claim, but it actually is an interest in securities. So it's not a market, it's not something you want to totally play around with in any way. And you want to be careful. And that's why a lot of people don't serve on committees when they're active and they're active in these cases. But the absolute rule is, if you're on a committee or you have any information, do not trade securities.
And would you, so you're saying trade, meaning it doesn't matter whether I'm the buyer or the seller. A committee member can't buy claims either?
I'm not saying claims, I'm saying securities. I'm
Okay,
saying
all right.
bonds or securities like that.
Let's
When you're
talk
talking
about
about claims, it's very spec specific, it's very duty specific. There are clearly trading going on by committee members. It's something you want to think about not only with a trade claim lawyer, but as well as a securities lawyer, thinking it through, as well as its fiduciary duties. There are clearly people on committees who are selling. It happens all the time. And it really depends on the committee. It depends how official the committee is. Depends if you're the head of the committee. Those are all issues you have to think about. It clearly happens. It's not something you should do without thinking about it, without advice of counsel. But you don't need an advice of counsel. If it's a security, don't do it. If it's a regular trade claim, think about it with your lawyers.
absolutely. Now,
Matt and Steve, I wonder if you could agree with this. If I'm on a official committee of unsecured creditors and I have, I'm a trade claim vendor or something that's a non-security, the expectation should be that they're going to be either the case or times during the case when you're receiving information that you're going to be restricted. And therefore, if you expect to trade or want to trade during that time, you should expect that you're going to have to go to your GC to counsel and go through a process before you can be comfortable that you're in a safe place to trade.
Yeah.
Definitely.
Generally think twice about it before you pull the trigger.
And do one of two things, which is either you're going to, I mean, this, not giving full legal advice on this, but if you're going to trade, you either should get a beefed up big boy letter, or you should disclose it but have the other person get an NDA and disclose it, just because of the right of private litigation, which is the two things you're supposed to do in this situation. I mean, openly disclose. And we do these letters all the time. I'm on a committee, I'm trading anyway, or you have the other person sign an NDA and you disclose it. I mean, those are kind of your two options most of the time. Don't do it without one of those two
the group,
things.
because I want to make this even a little more difficult for you, because I love it and it's really important. It's interesting to me. So I'm on an official committee and I'm selling my claim, but I'm selling my claim to the guy sitting next to me on the committee. Are there still the same issues?
Depends. Because it depends, there's different layers, right? If it's a security, the two of you might agree to a big boy letter, but you can't opt out of compliance with the securities laws, which are you can't trade when you have material non-public restricting information, and there's a duty not to trade. So that's number one. If it's not a security, I would still do it with a big boy, but it also, what did you sign when you were appointed to that committee? What are the rules of the road of the committee? What is the state of access of information that you have about yourself and the counterparty? I don't think I think these are some of the most important questions that traders or committee members can ask. And there's a reason that I always do them with two lawyers on the phone, because they're very, very fact specific. And oftentimes there's not a binary answer. You're often in a somewhat of a gray area. And there's business risk as well as legal risk. I had a great litigator that I worked with for many years on these issues who would say, who's going to get hurt? Who's going to complain? Once the investigation has begun, even if you're eventually cleared, you've lost. And so you don't want to be trading into situations with like the Washington Mutual case where you wind up with bad headlines and years of legal fees and investigations. And then the judge, says, you know what, this is okay. We can all go home now. And you've spent a year of time not focusing on your main business, whether it's trading or the case, and significant damage can be done.
Interesting.
I would just add a particular risk to your example, which I think David hinted at, and I think there was a recent case about this. I forget the name of it. Is that if you're trading with the person next to you, but they're acting as an agent on behalf of a third party. Let's say the person sitting next to you is Seaport, let's say, but they're really buying on behalf of a fund or a family office or something like that. And that family office doesn't have the inside information. An argument could be made, if there's no big boy letter, that they were just acting as an agent of that third party, and therefore you were trading with the third party.
Know who you're
And there was, I forgot the name of the case, but there was a case about that fairly recently, which has gotten most of the market much more careful, that even if the two of you both are on the same committee, that you still have the big boy letter because of the because you might be acting as an agent for a buyer.
And question for you guys, or in general, the standard agreement to buy or sell, the controversies arising from these agreements, where are they heard typically?
They could be, it could be a breach of contract of a committee agreement. In the case, it could wind up with, Steve, I mean, it could wind up with someone looking to expunge or disallow a claim. It could be a regulatory body. It could be the SEC. It could be the US trustee. Matt, who else? I mean,
Or it could just be a contract dispute, which could be
yeah,
heard,
Right.
which
that's
could be
right.
heard anywhere. And if you're trading with a Cayman fund, it could be in Cayman or who knows where. I mean, you can end up with some pretty, I mean, if it really depends if you've agreed to a trade and if it's a dispute afterwards. I mean, most trades are done under New York law.
So-
So chances are if you've already entered into definitive documentation, and it's just a dispute between the parties, that probably will be New York law, arbitration under New York law. But it could, if you get into the case itself or a third party regulator, it could be anywhere.
if I'm a buyer, can I put the bankruptcy court as the arbitrator for this decision, or bankruptcy courts in general will not want to get involved?
Steve, do you want to? I mean, it's a
I
good
think
question.
the answer to that is yes, yes, and yes. You can put the bankruptcy court as the jurisdiction, but the bankruptcy court may say, I'm not touching this thing, go somewhere else.
Yeah, in general, the claims trading market, particularly for the larger claims, is a pretty non-litigious market. And it's a pretty, I mean, I'm not saying it's honor among thieves, because it's really not. It's really people providing liquidity, but it's not a market that people generally honor contracts, particularly the buyers. And there have been cases in which I brought to clients and said, you should sue over this because they had disparity of information, and 90% of the time, they don't sue. But if it would probably be federal court of whatever jurisdiction under New York law.
Interesting.
One of the places where I've correctly seeing buyers utilizing the bankruptcy court is jurisdiction, is in connection with the transfer of the claim. And especially we've seen in FTX, we saw a bunch of creditors who sold their claim multiple times. So that is a place where you could use the bankruptcy court as an effective venue to deal with those types of issues that arise.
Interesting. Now, again, a question to the group, and then I'll move on because we're almost done with out of time. Can I split the claim myself? If I have $100,000 claim, can I sell 10,000 and keep 90? What do you think? Anybody? Would there be a prohibition?
It depends, right? I mean, it depends on the type of claim, and it depends the way that you want to split it. If you come to me, I can engineer something for you to do that. We often do partial sales of claims or participations in claims. We then get into the second hour of this webinar that we don't have on counterparty credit risk and funding. But yeah, there's all sorts of fun that we can structure into these things.
But the simplest answer, and David's totally right, but the simplest answer is if a claim is being transferred under the bankruptcy code, for the most part, the 3001E, the bankruptcy claims trading process does allow for the partial transfer of
That's
claims.
right.
Yeah.
That's right.
Where you see there are plenty of situations where it's post distribution, or for example, in Madoff, where the trustee in Madoff did a very interesting scheme of distribution and therefore basically made it practically impossible to transfer partial claims. I mean, there were cases in which we actually appealed it to transfer them because the entity was liquidating and so on. But when you deal with non-bankruptcy courts as your transfer jurisdiction, we've really only talked about here as bankruptcy courts as being your transfer jurisdiction, which it is for most part. But in Madoff, it was it was a different type of reorganization, and there they didn't allow partial transfers.
Well, guys, this has been educational. It's been fun. You've answered a number of my questions. I really appreciate this. You guys are clearly up to speed on this issue, and I would urge anyone who is out there in this industry to take a look at who's on these panels, especially this panel, and use them. So thank you very much, and we appreciate your time, and we'll close down at this point. Look forward to the next one.
Thanks, everybody.
Thank you.
Thanks.